journalist sources. Journalists can also refuse to answer questions.
I call the Honourable Leanne Dalzell.
I couldn't really resist joining the debate after listening to that contribution from Mr Calder. I'm sure it was well-meaning, but unfortunately somewhat misleading. And the reason that it's misleading is that it's completely missed the point that we have been kind of banging on about ever since this debate got started on this particular bill, and that is that these provisions, the requirements to get a warrant, do not apply to the Serious Fraud Office. And what we have been asking for consistently throughout this is to have the bill extended to cover the Serious Fraud Office. And I thought it was a bit unfortunate that the member concerned commented about the provisions in relation to police and then implied that they also applied to the Serious Fraud Office, when in fact they don't, and that's exactly our point. And I want to traverse some of the history of this, because I also heard the Minister make the point in her contribution that this had been raised very much at the last minute. Well, actually, the only thing that has been raised at the last minute has been the opportunity to address this problem in a way that could have been addressed at the Select Committee if we had the standing orders then that we have now. That's all that's changed. So we actually have the opportunity to put right a wrong that was done, not, I think, deliberately, but simply by reason of the fact that the Select Committee was given the advice correctly at the time that they couldn't make the amendments to bring the Serious Fraud Office within its ambit, because at the time it wasn't within the scope of the legislation. And in fact, if one refers specifically to the commentary, to the Labor minority view in this report, it states, "The Labor Party inquired of the government via Select Committee members and officials whether the government was willing to tighten the use of production and examination orders by the SFO at the same time as similar powers were being conferred upon the police under this bill. Officials advised that the government was not willing to do so." That was when it was reported back from the Select Committee, which I think was actually some time ago, probably November 2010 it was reported back to the House, having made an interim report back on the 6th of August 2010. So the position of the Labor Party on this particular part of the bill has been well known for a long time. But let me talk about the letter to the then Minister of Justice, the Honourable Simon Power, signed off by our then Shadow Attorney General, the Honourable David Parker, who's already contributed a lot to this particular debate. But he said in this letter, and this is the 9th of November 2010, he wrote, and he made it very clear about the SFO and talked about why it hadn't been included in either the Law Commission's report or, in fact, our legislation that we were going to be introducing at the time that we were in government. And he states the history quite clearly. He states, "The genesis of this lies in the proposal by the last government to merge the Serious Fraud Office into a new organised crime and serious fraud unit within the police." Now, that is exactly what the Minister herself from the Chair actually accepted was the case. At the time, the Law Commission advised the then Cabinet that the SFO was in the habit of routinely using their powers to use production and examination orders. So her statement that this was just a one-off event involving the NBR is simply not accurate. It does not reflect the history, and nor does it reflect what we were advised by the Law Commission either. We were advised that, in fact, this was a routine habit of the Serious Fraud Office. And the point was made in this letter, these orders do erode the right to silence and should be used sparingly. They were never intended to be a substitute for normal investigative practice, but rather were intended as a reserve power to be used to unpick serious fraud when normal investigative means will not suffice. And so the decision was reached by our government that we would proceed with providing these powers to police, but at the same time, with the decision to fold the Serious Fraud Office back into the framework of the police, that they would be picked up by those powers. So those restrictions that would operate around, appropriate restrictions that would operate around the use of those powers would apply to the Serious Fraud Office as it would to the police for that reason. And I think that that's a point that the Minister really hasn't, I think, responded to fairly, because she sort of has implied that this has been... Mr Chairman.
I call the Honourable Leanne Dalzell.
Mr Chairman, what the Minister sort of implied was that because this had been raised so late in the piece that there was nothing that she could do about it. Well, I want to refer to the Honourable Simon Power's response. The Honourable Simon Power sent his response to the letter of the 9th of November 2010 on the 25th of November 2011, the day before the election. Well, it was actually received after the election because it was received on the 28th of November 2011. Now, I don't know what that then Minister of Justice was doing, but I don't think this Minister of Justice would have let a letter lie around for that long before it got a response. But let me just, because she is actually mentioned in this particular letter, and I'll just read the section in relation to the Serious Fraud Office Examination Order powers. I have consulted with the Minister responsible for the SFO, Honourable Judith Collins, on this matter. The SFO's view, not the Minister's view, the SFO's view is that their powers were enacted in the SFO Act with agreement by both sides of the House 20 years ago and have operated with relatively little controversy since. Well, I could probably find legislation that was agreed to all around the House 20 years ago that none of us would want to have a bar of today. I'm sure there are plenty of examples of where things have changed over 20 years. The letter went on to say, accordingly, the SFO does not consider that an ad hoc change to one very specific provision in its Act is desirable and could potentially have an adverse impact on the effectiveness of its wider operations. Well, I think I just want to return to what Mr Calder said before, because he said that this bill was intended to implement a comprehensive reform of search and surveillance legislation, both as regards the core substantive law enforcement powers and the way search powers are exercised across the statute book. This does not live up to its expectation at all, and it doesn't live up to it for this very reason. Having absented the Serious Fraud Office from the coverage of this particular piece of legislation, we are unfortunately in a situation where the commentary, the introductory comments on the commentary of the government bill does not match the reality of the bill. And that's why we have made it absolutely our position from start to finish, and it hasn't just been a recent provision. It's a recent position. It's been our position throughout that this should extend to cover the role of the Serious Fraud Office. And I think that the recent examples that we've had in relation to the MBR are not the only examples. And as I said, quoting from the letter from David Parker to Simon Power back in November 2010, the Law Commission advised the Cabinet then that the SFO was in the habit of routinely using their powers to use production and examination orders. And if we are going to have this comprehensive reform, then it is important that the Serious Fraud Office is included within its framework. And I think that the Minister's point, I understand it might have been a position that could have been adopted if it hadn't been addressed at the Select Committee, but it was addressed at the Select Committee. There were submissions received on it. In fact, the question went back to the government from the Select Committee to ask specifically if that addition could be made. At the time, our standing orders didn't allow for this debate, wouldn't have allowed for this debate to occur in the committee stages, but we could have agreed through the Business Committee to do it. There was willing, I think, right around the House, with one exception, and really the grounds for the exception, for the exemption really for the SFO, simply don't stack up when one looks at the intention of this particular legislative reform. So even at this very late stage, I know that members on this side of the House would really like to see the Minister come to the party on this particular provision, because we would have agreement then. And if we were to have legislation like this, where you've got substantive agreement across the House, I know that some ministers might think that it's not important to have that level of agreement on such fundamental legislation, but I actually think it actually stands in really good stead. The weight that is given to legislative change when you can see the range of support that it gathers across the House. And I think in measures such as these, we should be looking at pretty much universal support in the House where we possibly can. And we were so close to getting that achieved in the discussions that we've had. I think just it's not too much to ask for that further step to be taken.
I call the honourable member Stephen Browning.
Thank you, Mr. Chairman. This bill has outrageous powers, and many